This week's top story is a victory for gun owners. ATF, under the leadership of Kash Patel, has rescinded its Biden-era zero-tolerance policy, which targeted FFLs and led to an estimated 500% increase in revocations during its time. In other words, an increase in revocations and therefore a decrease in gun dealers. Traditionally, industry operations inspectors, or IOIs, and ATF had some leeway when dealing with FFLs who were found to have violations during an inspection, which meant that options falling short of revocation, like remedial measures, were on the table. However, the zero-tolerance policy took those options away. While most agencies work with the industry they regulate to help ensure compliance with the law and regulations, ATF took a slightly different approach. Make a mistake, and your livelihood? Over.
Right to jail, right away.
The law allows for ATF to revoke a license for a willful violation of the Gun Control Act, and the way the courts have defined the term willful opens a can of worms. Some courts have said evidence of an individual's disregard of a known legal obligation is entirely sufficient, and others that the willfulness requirement was also satisfied by a showing of, among other things, a disregard of or an indifference to a known legal obligation. Put another way, an inadvertent error, like transposing one of the digits of a serial number or the customer screwing up the 4473, can all be willful violations. And as I mentioned before, the GCA says the government only needs to find one to revoke a license.
That does not make sense.
With the zero-tolerance policy off the table, hopefully ATF will work closely with gun dealers to bring them into compliance, rather than continuing to shut them down and restrict the people's access to arms, because after all, access to arms is a necessary part of keeping and bearing arms. I'd really like to hear from you guys about the things you'd like to see from Kash Patel and the ATF to support gun rights. Do you want to see them repeal something? How about amnesty for machine guns? Let us know down in the comments. Welcome back to the Big 2A, the show where we bring you all the top 2A stories. I'm your host, Adam Kraut. GunCon 2025 is coming up fast, and you're not going to want to miss this one. Not only will I be there, but there's going to be people far more exciting than me who will be there too. Come check out the fun stuff and companies at GunCon this year in Cleveland, Ohio on June 28th. Head on over to guncon.net to learn more. Would love to see you there. GunCon.
Still funny.
So great.
Say what?
Also in the news is how the federal government has created a pathway to the restoration of firearms rights.
Say what?
On March 20th, the Department of Justice posted an interim rule which rescinded the Attorney General's delegation of authority to ATF to conduct federal firearms relief determinations. So, ATF no longer doing that. Say what? Why does this matter? Federal law provides that a person who is prohibited from possessing firearms and ammunition may make application to the Attorney General for relief from disabilities imposed by federal laws, and the Attorney General may grant such relief if it is established to his satisfaction that the circumstances regarding the disability and the applicant's record and reputation are such that the applicant will not be likely to act in a manner dangerous to public safety, and that the granting of federal relief, or relief, not federal relief, just relief, I don't know why I'm saying this, would not be contrary to the public interest. So put simply, the person should be someone who's probably not going to be a dick again. Now, as the interim rule recounts, shortly after the ATF's creation in 1972 under the Department of Treasury, the Secretary of Treasury delegated the authority for these determinations to ATF. In 2002, when ATF shifted from Treasury to DOJ, the law also made clear that people seeking relief determinations must take it up with the AG. Of course, that authority was delegated back to, you guessed it, ATF. So, you might be thinking, but Adam, what's the problem other than things got shifted around? I'm so glad you asked. You see, in the early 90s, Congress became concerned with the number of resources that ATF was using to conduct these determinations, and that judging whether applicants posed a danger to public safety was a very difficult and subjective task, and that too many felons whose gun ownership rights were restored went on to commit crimes with firearms. So, what did Congress do in its infinite wisdom? Well, banned ATF from conducting these relief determinations by adding a clause in the appropriations bill that prohibited ATF from using any funds appropriated to it to do so. On top of that, the government wouldn't allow anyone to self-fund their own relief. So, essentially, if you were prohibited, you stayed prohibited. The interim rule is a big deal because Congress only bars ATF from using funds to conduct these determinations, not the AG or DOJ at large. By rescinding the delegated authority, the AG and DOJ can create a new pathway for individuals who are prohibited to apply for relief. In fact, the other week, Mel Gibson and 9 others were granted relief by the AG. While the feds have yet to provide any more information how regular people can apply for relief, this move to rescind authority is hopefully the first step in opening that program back up to the public at large. For you guys that don't know at home, most people are prohibited under 922G1, and that includes people convicted of felonies and state law misdemeanor crimes punishable by imprisonment of more than 2 years. As Judge Bibas said in one of his dissents, in New Jersey, opening a bottle of ketchup at the supermarket and then putting it back on the shelf is a third-degree felony, punishable by up to 5 years imprisonment. Of course, those people are absolute menaces to society, or something like that. The Gunshine State, that's a nice name for Florida, pause for boo, is working towards returning Second Amendment rights for 18 to 20-year-olds and has hit a bump in the state's Senate. In 2018, Florida passed a law raising the minimum age for purchasing long guns from 18 to 21 in response to the tragedy at Parkland, because no one lets a tragedy stop their political agenda in this country. In late March, Florida's House passed House Bill 759. Governor DeSantis has signaled his support for the bill, but the Senate seems to be a little less certain. Currently floundering in the Senate is a similar bill, which has yet to even be heard by a committee. And to add a little fuel to this fire, at the beginning of March, the 11th Circuit Court of Appeals upheld Florida's current law passed in 2018. Unfortunately, while Florida's political composition looks pretty good on paper, doesn't always mean a certain win for gun owners. Just ask those open carry guys. We'll be watching this one, but as of now, the only pathway to restore Second Amendment rights to 18 to 20-year-olds in Florida, at least on this issue, is through the state legislature. We're going back to Colorado. Quick update on something we previously talked about. Colorado's legislature passed its modified assault weapons ban, which is now awaiting the governor's signature. The compromise in the bill language, and that compromise was entirely Democrats negotiating amongst themselves, seemingly makes the bill more tenable for the governor's political ambitions to run for president in 2028. Even if he doesn't sign the bill, he will ultimately be pointed to for allowing it to become a law, which gun owners better not forget if he decides to run. But that's not all. On April 1st, Colorado's new excise tax on the retail sale of any firearm precursor part, the thing that isn't a gun, but they say could be a gun, is close to a gun, might be a gun, or should be a gun, blah, 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 or ammunition went into effect. Its rate, 6.5%. Of course, as you all know, another tax will simply increase the cost of firearms ownership and continue to disenfranchise people from being able to exercise their Second Amendment rights. What's more, if a tax at this rate is permissible, who's to say one at, 50% isn't? I want to know what you guys think down in the comments. Is it permissible for the government to add special taxes to firearms, or is taxation simply theft? Also, who do you want to see run against Colorado's governor for president? And do you understand the theory of relativity? I don't. Even though the tax was adopted by a ballot measure and recently went live, I've got some good news. We're suing them. At the end of March, the Second Amendment Foundation, along with some others, including the NRA, filed a lawsuit challenging Colorado's new tax. The lawsuit seeks to enjoin the tax from being collected, citing its inconsistency with this nation's history and tradition of firearms regulation, and various Supreme Court precedent stating that the government cannot single out a constitutional right for special taxation. With little ground to stand on, the state is seemingly in for an uphill battle, which means its tax could be short-lived. And that's good news for gun rights.